All right, so I think we're all here. Hi, everyone. Welcome, welcome. Glad to see the room full, and we also have online participants. So we'll just kick off the event. It's so great to have our UNIDROIT colleagues here making a special visit. So I'll hand the floor to our General Counsel, Thomas Clark, to make some introductory remarks. Thanks.
Thank you very much, Christina, and thank all of you for being here. Those of you who are happily joining us here in person, as well as the many of you who I know have tuned in online. I'm Tom Clark, General Counsel of ADB, really delighted to be here with Kathy Marsh and Christina Puck and so many other people from our OGC team, really to welcome, and it is an absolute privilege for us to welcome to ADB's headquarters, Professor Ignacio Tirado, the Secretary General of UNIDROIT, and Professor Anna Veneziano, Deputy Secretary General, and Mr. William Bertie Watson, Senior Legal Officer. All of you, thank you so much for taking the time to visit with us here at ADB. You know, we've recently had all of our ADB staff come back to headquarters after 2 years of being away, many people during the pandemic. I'm sure an experience that many of you are familiar with, but it's wonderful not only to be receiving our own colleagues back, but also wonderful international guests like yourself. They really help us to open the headquarters again and make it again a center for scintillating discussions like this. So thank you very much. Now, you know, this is a very high level delegation from UNIDROIT, which is such an important organization. And it's very timely, I think, to be sitting here today with Secretary General Tirado and his colleagues for this event, which is really, this event is all about sharing critical knowledge and learning about the important work of UNIDROIT, which supports many things, including sustainable development through advancements in the harmonization of private international law. Their work, as you know, covers a huge range of areas that are very relevant, critically relevant to ADB's own developing member countries. This ranges from things like international sales, trade, capital markets, agricultural enterprises, digital economy, just to name a few of the critical areas that UNIDROIT is involved in. In particular, UNIDROIT's instruments support agricultural development, and digital assets have great value in current times. We all know some of the difficult situations in the agricultural markets because of recent events, and instruments such as they'll be talking about today, digital assets have a great role to play. Now, I'm really looking forward to learning more about the crucial role that private law can play in supporting agricultural development and to help address the growing crisis of food insecurity in our Asia Pacific region. This is a real issue. It's a high priority for ADB, and I think we're going to learn a lot today. And of course, the emergence of digital assets provides risks and opportunities, so it will be very opportune to hear about the legal aspects of digital assets. Today's UNIDROIT's visit builds on cooperation established this year, starting from UNIDROIT's participation at ADB's webinar on innovative agri-finance products to help address food insecurity, which was held back in September, and ADB's participation at the 5th Secured Transactions Coordination Conference hosted by UNIDROIT in Rome in October. And I think Kathy was able to represent us there. Going forward, we hope to deepen our cooperation to help address some of the key challenges in the Asian Pacific region. So without any further ado, I would like to give the floor to Professor Ignacio Tirado, who's been serving as UNIDROIT's Secretary General since 2018. He's no stranger to the development community, having consulted with ADB on commercial legal reform, as well as the World Bank and the IMF. So thank you again. The floor is yours. Thank you so much.
Thank you, dear General Counsel, and everyone for the invitation here. We got the opportunity to meet in Rome a few months ago. One loses the sense of time with so much trouble, but it is, I believe, in a way, long overdue that UNIDROIT establishes a stable cooperation with the ADB, because, as we will see now, much of our work is related to, originated from, and applied by international financial institutions. So, enhancing our presence in this region is one of our key objectives. So that's what I'd like to talk a little bit about. There was a presentation. Can I just scroll forward? Let me see. No. Sorry, did I do?
That's okay.
Oh, there you go.
There we go.
That's me, right? So.
You have, I think they're going to do.
Oh, you're going to do it for me. Sorry. Right. Can you please play the next slide? Or maybe here. Yeah.
Yes.
No, all right. Thanks. Well, I would like to clarify that I'm a law professor, but I worked for many years with the World Bank in legal reform. I was based in DC for a few years, and then got back to my position and consulted. And in that context, after doing some work with the IMF once, I did work for the ADB, and she was working with me, and it was such a nice thing finding her again after all these years. My experience with the ADB was excellent, and being in East Timor, it's one of those jurisdictions where, being a Spaniard and being based in DC, you don't expect to get to know, and it was quite a very enriching experience in my life. So I'm very grateful for that. Enough of my personal experience with the ADB. Sorry, so there you go. All right. Okay, so let me introduce a little bit to you what UNIDROIT is, and I will not take long. So we are an organization which was established almost 100 years ago, 1926. In no time we'll be celebrating 100 years, and we are already preparing for it. Although it started as mostly a European organization, it is a global organization. It was created and founded in the context of the League of Nations, which, as you know, is the first global attempt at a world peace organization before the United Nations itself. We have 63 member states for the time being, which are not very proportionately distributed. As you can see, we have a strategy to increase our presence in East Asia and in Africa, and there is a reason for it. If you look at the numbers, our 63 member states account for almost 74% of the world population and more than 90% of the GDP. If you count what we call connected states, we reach 127. That means member states and states that have ratified one or more of our treaties and our instruments. And what we do mostly is, as was the ideal behind its creation in 1926, is to try to harmonize and modernize private law as a means for economic development and peace amongst nations, which that was originally the idea. Here in Asia, in the region, these are the countries of our membership. I'm not sure if all of them are countries of operation of the ADB. I would believe they are. But as I said, we would really like to increase our presence here. And for that, I would believe our collaboration with the ADB and partnership would be instrumental. So let me tell you a little bit what we do. There are three organizations in the world, or at least the three most active that do harmonization of private commercial law are the United Nations Commission on International Trade Law, UNCITRAL, the Hague Conference on Private International Law, and UNIDROIT. We are called the Three Sisters. That's we coordinate, we cooperate, and therefore we always make sure that our work is a work which is complementary to one another rather than something that we do overlapping, because our constituency is pretty much the same. So we don't want to squander. We are an intergovernmental organization, so we don't squander public money. The work that we do is about standard setting. So we try to come up with the ideal private laws. And we do that through a process which is quite interesting. On the one hand, it originates at the request either of a country or of an international organization. For example, several of our current projects were triggered at the request of the World Bank. We work with the IMF. We work currently with the Bank of International Settlements and the Basel institutions. One of our coming projects, the ones on sustainable development, will be started at the request of the European Bank of Reconstruction and Development. We have several instruments with UN-based agencies in Rome on food security and so agricultural activity. So the Food and Agriculture Organization and the International Fund for Agricultural Investment, for Agricultural Development, the IFAD. These are all organizations with which we work very closely. They either request that we do work on a specific instrument because they identify on the ground the need for it. For example, the model law on factoring, the World Bank identified that in many of the countries where it operates, access to credit is very complex. The only collateral that micro SMEs can access to is receivables, basically. And the laws on security interests of immovable assets were either too complex or were just not applied locally. So they asked us to come up with a law on factoring and supply chain financing because they identified the need. So this is the type of work that we do. That's how it starts. Then during the process, we select experts from everywhere in the world. We make sure there's a global representation of the different regions in the world because they obviously can provide different perspectives as to the needs that the law needs to address. We also invite observers. Observers are organizations that come from everywhere in the world. The World Bank, the IMF, the EBRD, they are all basically permanent observers in our work. And this is one of the things we like from the ADB, and to the extent that you are interested in some of our instruments, that you become an observer of the drafting process of these instruments. So you can make them a little bit your own. And when you go to country A to help develop their agricultural financing legal framework, the instrument which you can use is actually something which is in part yours, because in part you've contributed to its drafting. We of course invite the industry too, because what's the purpose of coming up with a beautiful instrument if the industry doesn't buy it? That's not an ideal way forward. And we do work in all these areas, as you've already kindly mentioned before: contract law, international commercial contracts. We are going to start now a project with International Chamber of Commerce on investment contracts and private law. We do a lot of work on capital markets, intermediated securities, close netting provisions. Access to finance is our thing, secure transactions, and we'll talk a bit about this. Law and technology is one of our new babies, like everyone's new babies. Law and agriculture, this is, you will find few organizations that do private law and agricultural work. You see a lot of organizations that work on the operational side of and public law side of agricultural development, but not of private law. We work on the contract farming relationships, on the agricultural land investment contracts side, on legal structures of agricultural enterprises. We try to come up with the private law expertise that channels agricultural development in a way which is sustainable, and it takes care of legitimate tenure holders, takes care of gender issues. So that's where we provide our input, and of course, procedural law as well. Let me give you very quickly an example of one of our instruments, because I don't think we'll be speaking specifically about one of this particular instrument, but I think it's worth mentioning. This is one of our signature instruments, the Cape Town Convention. The Cape Town Convention is arguably one of the most successful commercial treaties in history. It is it's a treaty which seeks to facilitate access to credit and lower the cost of credit for basically the leasing and the use of high value equipment. So, for example, it's a two-tiered system with a general convention, the Cape Town Convention, and protocols with specific rules depending on the different type of assets. Here I have for you the example of the aircraft protocol. The majority of the aircraft business nowadays is not done through the airlines owning the aircrafts. The airlines don't own the aircrafts anymore. They lease the aircrafts, and that's how they do it. And a majority of that leasing of aircrafts, it's done through the Cape Town Convention. We are talking here about 83 contracting states and the European Union for the convention, and 80 + 1 for the protocol. At this stage, we are around 1.5 million registrations in the aircraft protocol registry in Dublin. This means almost 1.5 million secure transactions have been registered in Dublin. You do that from here now in 2 minutes online for $100 is the price now. You can register a security interest, a security right over an aircraft worth $3 million for $100. That registration automatically provides you priority in case of default of the debtor. So you can imagine how the difference between the cost and the usefulness and effectiveness it provides. The estimated value of the collateral involved is now almost scraping $700 billion. The Cape Town Convention, simply by providing a very efficient and clear system of rights for creditors and debtors, it simply enhances legal certainty, and by enhancing legal certainty, lowers the transaction costs. It lowers the cost of credit, and therefore credit flows internationally. Why would that be? And I will not take a long time, I promise. You want to finance the construction and leasing of a plane, and you do that in country A, but the financier in country A knows that its collateral, its security for being repaid is an airplane. But airplanes have this strange vice of flying. So the airplane can fly to a different country, and that different country might not uphold the security interest that the financier in country A have. So in other words, the security interest could be completely a shambles. So what this does is ensure that if it flies to a CTC country, that and there's a default, that creditor will be able to recover. And that reduction in the cost of credit has been quantified by the OECD, and it's what's called the Cape Town discount for credit export agencies. This is just one example, and we'll talk about the MAC protocol, which is closer to agriculture later. So how do we go forward? And I'll leave my part here. So when our standards, therefore, ours, Ancestral's, The Hague's standards, model laws are there, and there's some sort of Platonic idea of what will be a modern law on factoring, on warehouse receipts, on digital assets. That's there, up for grabs, is there for everyone. But when that becomes something useful is when countries adopt the legislation and internalize it. And sometimes they do it directly, but many times, most often, they do it because the World Bank, the EBRD, the IMF tells them, you need to modernize your system of this if you want to grow. We are not going to give you our own model law because we are lending you, so it might be a conflict there, but you should look up. There are these public organizations which work in a democratic way, ensuring participation, global participation, which have these standards. Look at this model law and try to incorporate it to your own country. So there is no need for the IFI to pay a lot of money to an Australian law firm or to a London-based law firm to draft a law for a country, because this is already there. And frankly, a standard defined at the UN level or at the UNIDROIT level or the Hague level is much more adjustable to the local economy of an ADB or African region or South American region than a law drafted by a law firm in the city of London, which will most likely be thinking of a different scenario, even though you can adjust it, but adjusting it is not that easy. Changing from an English model law to an English law to and apologize, I don't mean to say that English laws are not good, they're very good, but they are English law drafted by English people for England.
Don't want a war going on.
I was just trying to tease her because I thought she was not. So no, I mean, this is providing state-of-the-art commercial and private law without the need to spend a lot of money in hiring law firms to do it, and especially getting the input locally. So I think it would be wonderful if, in the way forward, and the way F should be way forward, we work together in the standard setting activity that we do when we draft our model laws. We would love to get a request for work from the ADB whenever the ADB identifies in its countries of operation there's a need for a type of law, for example. Once that's the case, that you observe and become observers of our work and you collaborate alongside the World Bank and the EBRD and all the other IFIs. And perhaps if you're convinced with the final outcome that when you go to the country to assess the legal framework, you'll be willing to say, well, why don't you have a look at this? Because it could be good for your own development. So this is perhaps too lengthy an introduction, but this is all I wanted to say. Thank you. Go back to you.
Well, thank you very much. That's a really terrific introduction, Ignacio. And I have to say that even though it might not be something we work with a lot here at the ADB, your sort of description of the benefits of the Cape Town Convention, having worked for many, many years of my career in the private sector, including for what was at one time one of the world's largest aircraft lessors, GCAS. And I know one of our premier advocacy goals was always to get a given country to ratify Cape Town, because that would make things, and we had some success, including you.
I hope you haven't changed that.
Oh, well, good.
Yeah. So Tom, I was just picking up actually on the Cape Town Convention, and Ignacio, you described it as the most successful international treaty in history. And Tom, I agree with you that usually one would not associate the Cape Town Convention with ADB, but back in pre-COVID times, and yeah, I agree with you, the COVID time warp effect, right? But since I joined ADB, I had reason to look at the Cape Town Convention in the context of a particular financing transaction that our private sector operations department was looking at, where we were looking to essentially do a finance lease for an aircraft, through a slightly wacky structure, because why would it not be? The jurisdiction in question was actually a Cape Town Convention signatory. The twist being that there's a handful of pilots in the world who are able to land at the particular home base, but that again shows the true beauty of the convention and the application to probably the ultimate movable asset, because we took the view we can just wait until it flies somewhere else, that more people can fly in and out of without crashing into mountains. So no, very impressive achievement.
Like jurisdiction,
yeah.
The harder to get into, usually the more beautiful.
Yeah.
Well, thank you for that, Kathy. And I think, it goes to show that I think you're absolutely right that there's a lot of potential work for us to do together. But maybe, yes, let's turn it over to your colleagues, Anna and others.
I'm not sure. I think it's the arrow. This one? That one, yeah. Maybe. I think your colleague's going to hate me because I keep doing this.
Keep them on their toes.
There you go. this is an ongoing project now, together with Ancitra.
So thank you very much. First of all, thank you for inviting our delegation here. It's an honor and pleasure to be for the first time in the Philippines and for the first time at the ADB. I'm Anna Veneziano, the Deputy Secretary General of the organization, and I would like to speak about, as the Secretary General said, an ongoing project, which is a model law on warehouse receipts. So, which we are developing together with our sister organization, Ancitra, and I will say something about this new modality of developing a common instrument together. And so my first slide is actually more general, because I wanted to put the model law on warehouse receipts in the context of the more general work that UNIDROIT has done and is doing, both on the side of private law and particularly contract law and development in agriculture. And you see the UNIDROIT FAO IFAD legal guide on contract farming, which was already mentioned, and the UNIDROIT IFAD legal guide on agricultural land investment contracts. And then on the other side, the field of access to finance, which is a more general field where we are particularly active, as you know, with a specific focus in this case in agriculture. And this is why we will be talking about one of the protocols, the latest protocols to the Cape Town Convention, which is the mining agricultural. So the A is important here, and construction equipment protocol to the Cape Town Convention, which was adopted just in time before COVID stopped everything. And then, as you see, the ongoing projects in the current work program, which will all be finished as we think during the next triennial program. So one of them is a more general project connected more with the idea of contract law and development in agriculture, though there are some elements of financing there as well, the legal structure of agricultural enterprises. But then we have the model law on warehouse receipts, which is, of course, intimately connected with access to finance, particularly in this case for small to medium enterprises and looking at the supply chain. So this is what this project would like to do. So talking about how this project was started, the proposal actually came from Ancitra. To work together on this instrument. And of course, it's based on something you might know very well. So the growing relevance of the warehouse receipts in the financing of agricultural production and generally speaking activities, because of what I said before. So the fact that there is a focus on the global supply and value chain financing, and many of our projects actually go in the direction of looking at the chain and focusing on financing needs of small to medium enterprises, which is another priority at the moment. So the idea is that there is a need for providing international guidance for the modernization and reform of domestic laws in this particular area. And this for three main reasons. First, the fact that many legal systems do not have an enabling legal framework, or they have an old and not updated legal framework for warehouse receipts. The second important reason is that there is little harmonization and compatibility across jurisdictions, which has an effect if you have a global supply chain. And then the third, and this is really a focus of this instrument because it's something that would be new in an instrument of warehouse receipts, is the impact of new technology. And where we have quite a number of challenges encountered by legislators in enabling the use of electronic warehouse receipts. I will be very short on the work methodology because the Secretary General already talked about it. There was initial exploratory work. I think it's important to note the inclusive working group that was created. We have 12 legal experts, which really come from all continents. They, as experts, participate in a personal capacity. And we have actually 4 experts from the more general Asia-Pacific region. We have the participation, as the Secretary General said, as observers of several intergovernmental and other international organizations. And it is important then of course, public and private sector stakeholders as observers. It is important to note that observers in our projects are actually not sitting back and observing, but they are participating very actively. So the difference is that they are usually organizations or they are representatives of the stakeholders or industry. And their role is extremely relevant, as was already said, first in the development of a project, because you want to get it right and to hear what are the real problems. And then later on, and this is what we hope will happen, in its future implementation, because UNIDROIT is not an organization that does a lot of field work. And this kind of instrument actually needs participation and in a way, nationalization, because it has to be implemented within legal systems. Now, what are the expected outcomes of this project? First of all, the model law itself, which will be a set of black letter rules. The expected date of approval is 2023, so we are nearing that approval, but we are not yet there. The idea is to have an enabling framework which leaves, however, some flexibility to legislators in its implementation. So it's actually best practices. And the focus is on the private law aspects of warehouse receipt systems. So as we will see in the next slide, it's actually issues like the issue of a warehouse receipt, the registry system, the transfer of a warehouse receipt, the effectiveness as against third parties when you have, for example, a security right on a warehouse receipt, and so on. But of course, there are also discussions going on, and it's sometimes a policy question of whether certain aspects of the law applying to warehouse receipts should be left to the contract and to party autonomy, or should be regulated, or should be included in administrative or maybe regulatory law in the domestic law systems. And therefore, we have discussions on this, for example, for certain accessory obligations and rights of the parties, including the regulations and the more general regulations of how to organize the activity of the warehouse receipts. So what we, what the guide will probably do is that there will be a set of black letter rules focusing particularly on the private law aspects, and then we have a guide to enactment to facilitate the implementation at country level, which will be added to that, and it's expected to be drafted, completely drafted by 24, with commentary, with illustrations, but also with guidance for drafting implementing legislations, including reference to those regulatory elements that the domestic legislator should at least take into account. The other 3 points that I would like to make, which are of more general character, are that what we are trying to do is to be consistent with existing international instruments, particularly those, of course, developed by UNCITRAL, because they are global. And so it's the letter and also the model law on secure transactions. And this is particularly important when we think of using warehouse receipts as a collateral. Another important point is the compatibility with existing legal frameworks in relevant national legislation, because this has to be something acceptable by different legal systems. And then the rules should be technologically neutral. This is easier said than done, but we are trying to develop also the part on technology, taking into account the possibility of use of different technologies. But I will now skip to what are the private law aspects of the warehouse receipt system on which the working group is now actually developing black letter rules or discussing black letter rules. There is a first big area is the one of the issue of a warehouse receipts, and you see all the different topics that are addressed. One of the most important areas, which is rights and obligations of the parties, is still an area which is in discussion. There are a few points that are open because there are substantial differences in civil law and common law traditions, and also as among the legal systems, and in issues like introducing a duty of care, for example, or in issues like the liability of the parties, and in particular of the warehouse Then we will talk about the warehouse receipts registry system, the transfer of warehouse receipts, and the dealing with warehouse receipts by way of security. This is another open issue because of the need to render it compatible with modern international standards on secured transactions. And then the technology side. And so how to update how to introduce in an automatic way amendments to the warehouse receipts, for example. This is just one example of what is in the scope of application and the content of the model law. This is the last slide. You will be, I'm almost finished. This is just to let you know what are the next steps in this project. There are still 2 sessions of the working group to go. The 5th session now in December, and the 6th session in early 23. And this is what I was referring to when I said that it's a joint project. For the first time, we will have a phase first at UNIDROIT, and then a second phase at UNCITRAL for intergovernmental negotiations of the draft model law text. At the same time, a guide to enactment will be prepared, and then the expected adoption and approval, let's say, of the model law and the guide to enactment by both organizations is 2024. As you see, and you might have met virtually, Philippe Velin, who is the legal officer in charge at UNIDROIT, but if you want to have more information, these are the links where you can find more information, and we are, of course, at your disposal, and we are very happy to host you at UNIDROIT. This is to entice you to come to Rome and to come to our beautiful headquarters. Thank you.
With a picture like that, I think it doesn't need much more enticing. That was very nice. Thank you. Over to you.
Thank you and good afternoon. It's a pleasure to be here to speak for the next 10 minutes on both UNIDROIT's current work on a model law and factoring and our work on the MAC protocol to the Cape Town Convention, all in 10 minutes, which is fairly ambitious, but let's see how we go. So when talking about legal reform, I think it's always best to start with the problem it was designed to address when looking at the solution we developed. So in 2018, we received a proposal from the World Bank who said when they were going around the world and helping develop access to finance instruments and prepare model law on factoring or factoring reforms for domestic states, they'd identified a gap in the international legal framework, even though there were actually already 3 instruments in existence in this field. So the 1988 UNIDROIT Convention on international factoring only applies to international transactions, so it wasn't well adapted to domestic reform. The 2001 Assignment of Receivables Convention, again, only applied where you had parties in different states, so couldn't be used as a model for domestic factoring frameworks. And the 2016 UNIDROIT Model Law on Secured Transactions, which is obviously a wonderful all-encompassing instrument that provides a full secured transactions framework based on a functional approach. It wasn't. It's such an ambitious project that some states weren't ready for a comprehensive, all-inclusive reform of their entire secured transactions law. So what the IFC and the World Bank had found was that states were saying, we're not ready for the model law on secured transactions, but we do want to improve our factoring framework. What can we put in place? And there was this gap in the international framework that there'd been attempts to fill this gap by the private sector or non-governmental organisations such as Afro-Exim and the FCI. Both developed their own model laws on factoring, but because these weren't developed by intergovernmental independent organisations, they didn't really get traction. So on this basis, there was the World Bank came to UNIDROIT and said, we need an international instrument negotiated by an independent intergovernmental organisation on factoring, and that's how the project came to be. So it's a high priority project that will be finished next year. We've been working on it for the last 3 years throughout the pandemic. It has a dual purpose. Primarily, it's for pre-reform states, the states I just referred to, states that haven't yet developed a modern secured transactions or assignment receivables or assignment of receivables framework, but want to update or implement new laws to address this, to facilitate financing, especially for MSMEs. But interestingly, as we went through the process, it became the negotiation process, it became clear that states who actually had undertaken reforms in the last 5 or 10 years actually found that they probably didn't have enough specific rules to facilitate factoring, so actually wanted to supplement their domestic secured transactions reforms, often based on the UNIDROIT model law on secured transactions, with factoring specific rules. So it actually does have application not only in pre-reformed states that don't have a modern financing law, as well as post-reform states. So much like our model law on warehouse receipts, the instrument will consist of a set of black letter rules, and eventually that will be accompanied by a guide to enactment to provide guidance to implementing states. It's being developed as consistent with all UNIDROIT methodology through a group of international experts from common law, civil law traditions, different linguistic backgrounds, and of course observed by IFIs, by international organisations, and by the private sector. And where we've just undertaken a public consultation, and we're hoping to essentially finalise the draft at a meeting in 2 weeks' time. I'm not going to go through all 54 articles for obvious reasons. Oh, please, you have nowhere to be for 6 hours, right? But the reason I put this up, and the reason I want to note 54 articles, which may in itself sound like a lot, it's comparatively to its sort of the other instrument in the field, the model law on secured transactions, it's 65% shorter, 25% fewer articles. Now, this is very important because if states are saying to us, the model law of secured transactions is too long and complex, if we introduced an instrument that was equally as long and complex, we would have failed in our mission. So we believe that even though the core legal rules and the structure is based on the model law on secured transactions, we have managed to shorten and simplify it because we've been able to exclude a whole bunch of transactions that don't relate to the assignment of receivables quite naturally. That being said, it's still a complete self-standing legal regime. So if a state does implement all 54 articles and 25 registry clauses, that in itself will provide for a complete legal framework. You don't need additional rules. I won't spend too long on the deep legal substance, but I thought it was important to mention that the way we define receivables is a contractual right to a sum of payment of a sum of money arising from supply or lease of goods and services, very sort of classic factoring, arising from contracts for the license or assignment of intellectual property, and representing the payment obligation for a credit card transaction. We're also going to include an additional fourth area in relation to data transactions, which have obviously become more and more a product that is often financed more and more in the sort of the digital sphere. and that wasn't in the previous instruments, but we think we've got a solution for the working group to discuss on that particular issue in 2 weeks' time. It applies to both outright transfers of receivables, as well as the creation of security rights in receivables, which we refer to in the draft model law as security transfers. And it applies to both domestic factoring and international factoring, and allows for the transfer of both future and present receivables. We have a few exclusions to make sure that it's narrow. We exclude receivables arising from the sale or lease of a movable property, because they're often subject in many countries to specialized legal frameworks that countries don't want to play with and don't want to tinker with. And various, again, similarly, various financial transactions, such as financial contracts governed by netting agreements, receivables arising from foreign exchange transactions. These are, again, types of financial receivables that are often governed by very separate legal frameworks. And if you tell an implementing state to include them, you're going to run into significant regulatory issues. So we've tried to be quite limited in our scope to make sure we don't run into issues, but broad enough that it covers 90% of what a factor will do when they're financing some of the receivables in an implementing state. So the entire system is based on a transferor-based registry, which the implementing country must set up, which has obviously become international best practice. Once registered, a transfer is effective against third parties, and priority is determined by order of registration. Those of you who have worked on secure transactions and receivables implementation projects will be very familiar with all of this. We've put the registry rules in the annexes. Obviously, the registry rules are a fundamental part of this legislative package, but the model law on secure transactions includes the registry rules in the bulk of the article, but we wanted to sort of separate them out to make it clear that there are almost two sets of essential rules, but are very, very different in how they operate. So we're very much at the tail end of this project. We have had 5 working group meetings. We did a 3-month consultation on the draft model law on factoring. We received over 200 comments. We're in the process of going through those comments. We'll have a final meeting in 2 weeks' time. It will go to the Governing Council next year for adoption, and hopefully between June and December next year, we'll be able to send the ADB a copy of the model law on factoring in both French and English. And then, as Anna noted, similarly to the guide on the model law on warehouse receipts, we do need to also create a guide to enactment to assist implementing states and give guidance. And I would suggest that this would be a wonderful time for the ADB to engage with this project, because it would be very useful for us to hear, when we're developing the guide to enactment, whether there are realities on the ground in implementing these types of reforms in ADB, under ADB projects, where there needs to be tailored guidance for implementing states based on issues that you have come across. So we would certainly welcome the ADB joining the working group for the guide to enactment once that kicks off its work next year. I have 3 minutes left for the MAC protocol, so let's do that. Thankfully, we've already had an introduction to the Cape Town Convention by the Secretary General, so I can skip this slide. You're all aware it's one of the most successful international commercial law treaties in history. It is applied to different sectors through protocols: the aircraft protocol, the rail protocol, the space protocol, and the mining, agriculture, and construction protocol. Each protocol adapts the rule to that specific sector and the financing realities in that specific sector. And so the MAC protocol was the most, we can skip this because that was already covered. So the reason that it was decided to develop a mining, agriculture, and construction protocol was because the Cape Town Convention, the aircraft protocol, had experienced outstanding success very quickly. There was a desire to increase the economic benefits to developing countries and emerging economies by extending it to the primary sectors, to sectors where developing countries tend to have a particularly large percentage of their GDP arising from mining, agriculture, construction, and to address other issues of global concern: food security, infrastructure, climate change. So it was developed over a fairly long period, over about a 13-year period, and finally adopted in November 2019, which we're all very happy with. Obviously, the timing wasn't great, 3 months before the whole world shut down, but we managed to get it in before. Could have been worse. Wasn't great, could have been worse. But essentially, in developing the protocol, we had an independent economic assessment undertaken on its likely impact, which unsurprisingly was very significant. given the fundamentally important nature of the mining, agriculture, and construction sectors around the world. The MAC protocol, if implemented, the economic assessment was based on the 63 UNIDROIT member states. So this isn't assuming global ratification, just partial ratification. It predicted to increase the global stock of MAC equipment by $90 billion over a 10-year period and increase global GDP by $30 billion a year. 23 billion of that would be for developing countries and 7 billion from developed countries. For the very simple reason that developing countries tend to be more reliant on the mining, agriculture, and construction sectors. So naturally, they're better positioned to reap the more of the benefits from it. Most of the developed country benefits come from increased sales from the because they're mainly manufactured in developed countries. This is an import-export map in relation to the $123 billion worth of MAC equipment within mining, agriculture, construction equipment within the scope of the protocol, imported and exported every year. I note there's no good or bad countries in terms of colors. The bluey green means that they export a lot more than they import, and the red means they import a lot more than they export. So on that basis, generally speaking, the red, orange, yellow countries are probably poised to reap larger benefits because they're net importers and therefore will have access to finance for a significant amount of goods that they import. So it's a little bit hard to say that, especially in the sort of the ASEAN region, there's a lot of net importing countries that would be large beneficiaries of the MAC protocol, as set out in this slide. So in the Asia Pacific, we're looking at the scope of the MAC protocol is determined by 56 harmonized system codes, sort of the codes that are used for commodity trading and goods trading across the globe. Is the entire basis of the UN trade system. Anyone who's done a bilateral trade treaty or a multilateral trade treaty will be very familiar with the harmonized system. Of those 56 harmonized system codes that cover the mining, agriculture, and construction equipment, that constitutes $34 billion of exports within the Asia Pacific region each year and 18 billion worth of imports. Here you see the largest importers and the larger exporters. As noted earlier, we expect, while exporters will benefit from additional sales, the importers are best placed to benefit because they will be able to benefit. The mining, agriculture, and construction sectors in those importing countries are better placed to benefit from the lower cost of finance. So we've had 5 signatory states and the EU signed the treaty thus far. We are in the process of going through the regulatory framework required for the MAC protocol to enter into force, which is to create an international registry, appoint a supervisory authority, and develop the regulations. We expect that all of the sort of regulatory steps will be set up in the next 18 to 24 months. And once we get the 5 ratifying states we need, then hopefully it will enter into force. So we're currently working with a lot of interested countries around the world to try to encourage them to implement the MAC protocol. Obviously, this isn't a project that the ADB would only work with on this as one particular instrument. But if you're working in a country and you're working on access to finance, agricultural law and development, strengthening the international legal framework, supply chain finance, international trade, this is a very easy thing to add to a broader framework because it's a very easy treaty to implement. And importantly, it doesn't require the establishment of a domestic framework or a domestic registry. There's already an international registry created. So we certainly would love to speak to you more about it and hope that there might be some extent that you can promote this in some of your work in the region. I've gone 2 minutes over time. Thank you very much.
That's really a terrific overview. Thank you very much, William. And I don't know if you were doing it deliberately, but at the end there, when you were going through, if you're working on, you named like half of the entire like LPR program that we have here in terms of the things that we focus on in terms of financial inclusion and looking at, promoting cross-border trade investment. I mean, things like that. So definitely a lot of, I think, work that we can look at doing together. So we are running a little behind, but I think that the next section is really important, and that's the area of challenges and opportunities and the emergence of digital assets, which I know a number of us are quite interested. Some of our departments, our economic research department, other organs in the bank are looking at this critical, of course, in the agriculture area. So back over to you.
Thank you very much. I will be quick on this as well. This project started at the request of two of our member states, but it grew exponentially because this is what everyone is talking about, right? So the idea was to confine the analysis to digital assets and private law. So because we want to be technology neutral, therefore, to the extent possible, that the analysis we conduct is still useful in the next Monday, because things change so quickly in this area, which makes it absolutely impossible to chase the technology. So the type of analysis is done in a way in which is supposed to be functional and is supposed to be technology neutral, it is about applying the how to transact with those, how to create security interests, how to enforce on them, what happens in case of insolvency. So the difficult overall general private law questions that one has over any type of asset, but how they would be applicable to these types of assets. So you don't expect work which is extremely technologically developed, because it is obviously we have a number of very clever, very strange techies working with us in this in this project, but it's more about the legal private law analysis that we conducted. It grew exponentially, so much so that we had to create a parallel governance body to follow this work. So apart from our working group of experts and observers, which would be here, some of them, we had to create a steering committee. A steering committee is composed of a number of over 30 member states scattered around the globe that provide input on the basis of their special local market or local reality. So we make sure that we actually have the instrument which is being created by the experts and the observers and commented upon by countries from all over the world. So it's become a very, very large group, and it's been very successful, I would think. The part which I would like to also stop for a second about is, this is a new area, unlike warehouse receipts, which has existed for more than 100 years everywhere, and you deposit your crops and you get the receipt and you trade with it. The new part, the part we're doing now, is you create a standard to trade it electronically, to then to use the platforms to make sure that financing arrives in a more streamlined way. And this is different. This didn't exist. So there are no standards there. There is no best practices there. In fact, when you talk to the people and to those who use the systems, what they tell you immediately is, we don't want lawyers, we don't want any regulation. This is about precisely letting us do whatever we think. And of course, this is already started to create a lot of problems, as we've seen in several cases very recently of the problem with the absence of regulation. In fact, one of our principles expressly states, anything concerning the proprietary rights over digital assets is a matter of the law, which is a very strange principle to read, but for this type of reality in which those that create these assets think this is nothing to do with the law. We create freely, and we will continue to do so. So our standards, which are in the final process of drafting, our work is very similar in its outcome with the results that, after a long debate, the Uniform Law Commission of the United States, with this reshuffled Article 8 and revision of Article 9 had, and the same happens with the Law Commission of England and Wales. Both we observed on their process, they observed in our working group, and the fact that we've kind of reached some sort of agreement as to what digital assets are, how you trade with them, how you create security interests over them, and how to do it, is quite reassuring, because if you don't think UNIDROIT's work is enough to call it a standard, when it is pretty much coincidental with what the Uniform Commission of Law of the United States, Uniform Law Commission, or the Law Commission of England and Wales have said, it starts to build as some consensus in the international community. Very briefly, because we have very little time, you might be wondering, especially those of you who are experts, what is a digital asset? Because a digital asset can be anything. So we are, because we are on the private law functional part, and we've built upon the previous work of our sister organization, UNIDROIT, which has its model on and electronic transferable records. We first define electronic records, linking it with UNIDROIT as information which is stored in electronic medium and capable of being retrieved. But we take a step forward, and for us, digital assets and our principles apply to electronic records which are capable of being subject to control. So control is the word. Control is the word to create security interest. Control is the word to transfer a digital asset. And for a US lawyer, this sounds familiar, because control is what you use for securities, intermediated securities, and other types of. So control as the function equivalent to possession, because obviously you can't possess a digital asset. So that's how you use this. Of course, you won't be surprised to hear that our initial, we very quickly came to the conclusion that digital assets actually can be the subject of proprietary rights, because if we hadn't concluded that, then this would have been the shortest project in the history of the organization. So that was the first thing that we agreed upon. And I think at this stage, this might sound very, very evident to all of you, but you should know that, for example, there are many civil law jurisdictions, allow me to mention, for example, Germany, where immaterial assets cannot be subject of proprietary rights. So it's not that evident, and this is obviously an immaterial good. So we had to grapple with these differences in approach to the types of assets. Another thing which is, of course, very important is, I'm sorry, I skipped one. Well, I did it on purpose. So we've taken an approach which is relatively modest, in the sense that, for example, in the case of digital twins or linked assets, we basically said, our principle basically says, we're going to deal with the digital asset, but we are not going to say anything about what that means in the real life asset, because that is something for the relevant law to determine. So, you know, we can deal with digital assets over gold, but whether what we've done with the digital asset actually creates a pledge over the gold or not is something which will be determined by the national law. And that would take us to principle 5, which is one of the most important and difficult ones, not here because it's still under discussion together with The Hague on applicable law, and private international law matters. Was the law applicable to digital assets? And our approach, of course, as couldn't be otherwise, is very much linked with choice by the parties. The law would be that of the digital asset or of the platform where it is negotiated. And if not, we provide a sort of waterfall type of possible ways of determining the applicable law depending on the situation. But that's for when we have 2 hours instead of 15 minutes, and not even so. We define control we'll provide you with all these materials, because we don't want to. Another area where we are actually very active is in the work of, we incorporate very intensely analysis on custody. And custody is defined in a general way as, in a way similar to what you would call an intermediary in the world of intermediated securities. So the analogy here for digital assets would be those of intermediated securities, with some specialties, of course. And we think that, at least the experts think, that a different analogy is very difficult to find, really. I'd like to call on something which I believe is important. The very definition of custody agreement, which we include, already defines custody as that relationship whereby in case the custodian becomes insolvent, the asset does not belong to the insolvency estate of the custodian, but rather belongs to the owners of the asset. So the effects in insolvency is already part of the very definition of the custody relationship that we are considering here. Again, we use the concept of control for acquisition. We have rules on innocent acquisition and more complex matters. We analyze in some detail secured transactions concerning both perfection and the creation of binding security interests over third parties and how they are to be understood and where we think that a proper security interest has been created over the asset. You have to think that in terms of digital assets, the traditional approach doesn't quite work, because it is not only that we have an immaterial asset, is that every time there's a transaction, the previous asset disappears and a new asset substitutes it in the ledger. So it is applying classic private law concepts to this has a lot of problems. We have a rule of insolvency, which is actually quite interesting because it does provide a rule which is quite protective of the owner of the digital asset and the owner, to the extent that you can actually identify it, should have proprietary rights to the asset. And more importantly, a very lengthy but quite innovative principle in case of insolvency of the custodian or the intermediary, as you want to call it, be it a custodian in strict terms or an exchange, which is, apart from what I said before, which is if the custodian or sub-custodian become insolvent, the creditors of the custodian do not have an access to the assets as such because they're out of the estate. But what happens when, as happens with intermediated securities, for example, the assets are commingled in an omnibus account, the rule that has been reached here is that of a proportionate allocation of the losses between the owners. So there are a number of quite advanced solutions to the problems of digital assets, which we're of course very happy to discuss, and having the input of the experts from the ADB will be great. This is where we are now. We're about to have 2 more working group meetings, which will take place in December and March. We'll have industry consultation and drafting committee sessions, and that will be taken to our governing council. So that's where we stand. Thank you.
Well, Ignacio, I think that was an incredibly rich and concise exposition of a lot of work that's going on, and really exciting. And I know that it's been so full that we are pushing up against our time limits. But I think the next section here is actually one that's very interesting to me, and I'm sure to all of us. And maybe we'll have to be a little bit succinct, but I think it's the beginning of a long discussion, frankly, and that's, Asia-Pacific regional engagement and future work. And I hope that includes a lot of opportunities where we can work together. So would be grateful for your thoughts on that, William.
Thanks, Tom. And I'll be incredibly succinct here, especially because, as you said, this is almost the subject of what we'll go on to discuss later this afternoon. But just to give them an overview of the other participants here, I'll try to do it in about 2 minutes. As set out by the Secretary General, we have very strong global membership in terms, especially if you look at it through the lens of world population or global nominal GDP, but we are undoubtedly underrepresented in the Asia Pacific. There's no doubt about it. We have only 10 member states in the region and 3 governing council members from the region, which is actually about in proportion to the member states. This is very much an outcome from our of the sort of the historical basis of UNIDROIT as being a 96-year-old European organisation that for a long time just most of our member states are in Europe, but it's something that UNIDROIT is very much looking to change. One of the reasons we're here in Manila this week. So despite our membership being a bit low, we actually have our instruments here have been very successful. You see, despite only having 10 member states, You have 25 countries that have ratified the Cape Town Convention in the Asia Pacific region, and 11 countries that have ratified our work on the protection of cultural property, which we haven't mentioned today, which is sort of a different area.
That's because we are so nice that you don't need to be a member to ratify our instruments.
Yeah, we're too nice. We have lots of participation from people in the region in our work. And so given that we have this low level of member states in the region that we need to increase, the way we're trying to improve our engagement is to engage through regional bodies. We have guest status of the APEC Economic Committee. We're trying to work with the IFIs and through the ADB. We cooperate with our partners, with UNCITRAL, with the Hague Conference. We've worked very closely with the World Bank Group, as mentioned earlier. So we try to make sure that whenever someone from UNCITRAL or the Hague Conference comes to the region, they speak about UNIDROIT's work and vice versa. Hence, we're promoting them here today as well. And as I said, we have an established position within APEC. We've been working within APEC to the Economic Committee, where we attend every 6 months. We've been doing that for 6 years' time. We found that to be a very useful forum, especially as they have a subgroup on strengthening economic legal infrastructure, which allows us to promote a lot of our access to finance work. We've also worked under the ease of doing business subgroup as well with some success. And as you see there on the side, is where we want to improve, where we want to increase engagement is through the Asian Development Bank, is through ASEAN. We've had a first meeting with the AAIB as well, and we'd like to also make contact with the Pacific Islands Forum. I think I'll leave it there to leave maybe at least 1 minute for questions. Thank you very much.
No, again, that's a very concise, but I think invitation really to further work together. And I mean, your work with APEC and other organs here in the Asia Pacific certainly shows that you have the interest, and delighted we'll be continuing, as you say, a discussion later this afternoon about, but maybe if folks have just a few minutes to go over, it would be great to have a little time for Q&A. And I don't know if we can just, if we have a mic for the audience, or others just want to step up or raise their hand, please.
Will, I would just like, clearly I have a reason for flagging this, but the MAC protocol, in the context of mining, as I understand it, that would apply to mining fleet. And perhaps we could spend literally just a couple of minutes this afternoon just touching on, if I'm a lender financing a mine, how does the MAC protocol, how does that help me? Would be my question on that, because I get it for aircraft, the ultimate movable asset. Mining fleet. I mean, actually, the most valuable bit of mining fleet is the tires. It's not the trucks. It's the tires. But yeah, I'd be quite interested in that. As I say, there is obviously an ulterior motive behind that request.
If you give a short answer,
yeah.
It's a very good question, and mining is one of the most difficult parts of the mining agriculture construction, because the assets tend to be deployed almost for their entire life. On a mine, you don't have as much movement as you do with construction. Obviously, you move between construction sites. Agriculture, absolutely. Mining, you often have a $10 million drill or $500,000 dump truck, put on a mine for its lifespan. There's also complex issues with the connection between immovable property and the assets and how that affects any secured transactions. The good news is on that, we have rules in the MAC protocol that addresses that to actually strengthen the lender's rights if a good gets, if mining equipment gets attached or affixed to mining property under the domestic system. That would usually mean that an interest, a security interest or an interest over that asset would disappear or be subordinated to the immovable interest. That there's a rule in the MAC protocol saying actually if the contracting state makes a certain obligation, your international interest is protected as long as it's economic to remove. If removing the drill would cause $10 million of damage for $1 million of benefit, you couldn't do that, but we have that. In terms of fleet, it's a more complicated question that also goes to the heart of the value of an asset-based financing instrument in a project-based financing sector. But we certainly, there are 2 points I'd very quickly make. One is that the financiers of large mining projects said if we can get better financing over the often tens of millions of dollars of equipment and ensure that we will, if there is some sort of insolvency or some sort of default in relation to that, that we will still have better access to that equipment as in circumstances where we usually wouldn't, and that would still strengthen, that would still encourage us to use the protocol to ratify interest international registry. And the second point is that in some countries, you might already have quite good rules in relation to fleet and in relation to inventory financing. And the MAC protocol actually allows you to preserve existing inventory financing systems, especially if you had thousands of assets coming in and out of inventory, having to re-register and deregister them each time on the international registry might be overly burdensome. So we've tried to adapt the treaty with unique provisions that aren't existing in the earlier protocols to try to deal with some of those peculiarities, in particular for the mining sector. But we can talk about this in more detail in the next few hours. Thank you.
No, thank you, Will. And I think, the other point about mining fleet in particular is it's so dependent on the geography, right? If you can just drive your dump truck, over the border to somewhere else, that's one thing. But yeah.
I just very briefly to this. The Cape Town Convention plays two roles. One of them is to provide legal certainty for those assets that can actually change borders. So because that would on its face change the legal system. But on the other hand, it also has a function of modernizing the legal system of security rights over movable assets of high value in countries where the system is not very workable. And there are not that many countries which can provide you with an adequate security interest over mining equipment, especially in cases where it becomes part of the land, so to say, and things of the sort, which actually undermines severely the rights of the financier. So it helps modernize the system without really interfering with the legislative process of the country, because you don't need to change your law to adjust to it. So for countries, some countries this will not be necessary, for other countries it will be necessary.
And I guess, but a principle that's broadly in play here is that for some things like the perfectibility, you might still be looking at, the general law, once the interest is created and recognized under the, the MAC or the aircraft. So it's I guess integrating and leveraging the secure transactions law or the insolvency law or whatever. Yeah.
If I can add to that, this is true, especially in the sense that many times what we have seen is that you have both an international interest which is created and a domestic one, because it does not actually displace the domestic one. So you can actually then, according to what is the situation, use both.
Oh, and that's not that unusual. If you have more questions, please.
Nice to see you. And then my name is Joseph Curie, and then I'm currently working as financial sector specialist at ADB. And it is my honor and pleasure to see Professor Hansom's Professor Ignacio again since 2019, when I participated in the general meeting of UNIDROIT in Rome. As one of the Korea delegation. And 2019 in Korea, the Electronic Securities Act was enforced, and then it includes some parts of the digital assets. And then since then, I have been participating in the digital asset related acts and other matters. And then what I'd like to ask Professor Ignacio is the progress and the future plans you have regarding the preparation work relating to the digital assets. And while the many countries, including Germany, Switzerland, Japan, and Korea, even the United States are preparing for the digital asset related laws and acts. And then it is quite noteworthy for United States, which is considered to be a kind of common law-based country, to start to adopt the financial market infrastructure-based laws. So in their uniform commercial code. So how do you prepare, and how do you expect the timeline? And then one more later question is that how do you evaluate the possibility or feasibility for the member country to adopt the digital asset related model you are going to prepare? Because I was also I have a memory to participate in the Geneva Convention before, but as you know well, still member countries in the UNIDROIT have not adopted officially the Geneva Convention relating to intermediate securities. So I'd like to know your opinions about this. Thank you.
Thank you very much. It's very good to see you again. I hope you look just the same. I hope you can say the same. So there are several questions and assertions in your very good words here. One of them is perhaps touching upon the approach that we have to digital assets concerning the different legal families, because one thing is the approach of civil law jurisdictions and a different one is that of common law. And as I said before, we do have come after a very thorough discussion between both types of legal family members that for digital assets, a bit like for intermediated securities, I wouldn't say the common law approach, but a more functional approach, less rigid to concepts, is the one that should work, especially in an area where reality is completely new. So, for example, that of control. The chair of our working group is Professor Hideki Kanda, previously from Tokyo University, now retired then, and now is at Gokushuin. We count on Luc Thévenot, professor from Geneva as well, who took the more civil law approach, which was, toe to toe with the members of the Uniform Law Commission of the United States, who have a more functional USCC type of approach to things. The common law part, if you will indulge me by calling the English Law Commission, is actually somewhere in between. It might sound like some people tend to put America and UK law in the same pot, but it actually doesn't go together very well. It's more like in between both in many ways. It is in many ways somewhere in between, isn't it? The final outcome is quite balanced, I think, and it's the outcome of very thorough, good faith discussion between both worlds, and I think it's acceptable to everyone. So we're very proud with that, although the process is still ongoing. There are still some French experts trying to pull from the so this tug of war still happens a little bit. But this is how things work in international law organizations. Follow-up work we are going to be doing on this is still to be determined, but related, although slightly different, as you may understand, is the work we're going to be doing on voluntary carbon credits. We're going to be doing a similar type of analysis on voluntary carbon credits and how those are to be traded, how to be used as security interests. Now, a little bit of the same type of analysis. We are not going to be getting into the regulatory part of VCCs because that is public law, and whether you have a certificate, you earned a credit or not, is something for the country or for another organization to say, not for us. But once you have it, how you deal with that, because there's a lot of regulation in many developed countries. The European Union is one of them, the United States, in many countries. But in a lot of countries, especially in the global south, where these credits are supposed to be very important going forward, There is very little or no regulation whatsoever, and some clarity as to how to deal with these assets is going to be necessary, we believe. I'm not sure if I addressed all your matters. I don't think I did, but I'll be here for a while, so feel free to. And apologies if I haven't.
Thank you very much. And thank you, Joseph, for that excellent question. I think that we are going to have an opportunity both later this afternoon. I know that your department has been doing some terrific analysis of the state of digital assets around the world, and definitely we can continue to collaborate. I think at this point, I'm just going to those of us who are joining online, going to have to draw the webinar to a close, but not before thanking all of you who joined us online. I hope this has been interesting, and really it is kicking off a long conversation that I think will be very fruitful as we move forward. But thank you for those who joined online, and we will continue here with some further events this afternoon. But thank you very much. Thank you.